Case number 16-100661. This is Progressive Michigan Insurance versus Toyona Pope. The matter is before the court on the filing objections to a writ of garnishment as to the Michigan Department of Treasury. The record should reflect in this matter that a judgment was entered in this case. Looking at the summary just one moment here. Looks like that was sometime in 2016. And the total amount of the judgment was in the nature of $5,800. Are that your appearance for the plaintiff counsel?
Judge, I think they're in the breakout room. I think.
Which is that independent emergency?
This is Progressive versus Coleman.
They're in the breakout room.
Yeah, I see. We'll come back to that. Thank you, Madam Reporter. This is case number 19-155900. This is Michigan First Credit Union versus Dallas Calhoun. The matter is before the court on filing objections to a writ of garnishment. The record should reflect that this is in relationship to the Michigan Department of Treasury. In looking at the register of action, it appears that a judgment was previously entered in the nature of $8,942.56. That judgment was by consent on September the 19th, 2019. Your appearance for Michigan First Groups.
Good morning, Your Honor. Michael T. Manett, P81102.
All right, thank you, Counsel. Good morning to you, sir. I'm looking
Good
for Dallas Calhoun at this time. Say something in there.
Good morning, Your Honor. Can you hear me? I'm sorry, because the volume went really low.
That's all right. Can you hear me? Okay, I hear you. I hear you perfectly fine.
Let me. I could at first. Let me try and.
Good morning to you.
Good morning.
Okay.
Let me try and see if I can. It was louder than that, and it went. Maybe that's it.
Okay, you hear me okay now?
You just sound really far away, and it wasn't like that at first. But I can hear you. I'm just kind of straining to hear because I have my volume all the way up, but I think I can make it out, Your Honor.
All right. Well, let's try and get to it. I do see that you filed an objection to the garnishment, and you pointed out that you have an installment order that was entered in 2022, and so you're objecting on that basis, correct?
Yes, Your Honor. I have been making my payments. I probably was late on one of them, but every chance I get, every couple extra dollars I get, I'm paying it. I'm not missing any. I have registered to take a credit counseling class because I'm trying to understand, better. I haven't really gone through this before, but I'm making payments as best as I can. So I'm not understanding why they want to try and garnish me even more if I am making payments.
Well, there are two major different types of garnishments. One is the garnishment where there's taking money from your wages and things like that. As long as you're paying under the consent or under the agreement, they can't engage in that type of garnishment. But that does not prevent the type of garnishment of a bank account. It doesn't prevent garnishment of income tax return. And it looks like that's what's going on here. As long as you're making payments, they can't garnish your wages. But that does not prevent the other types of garnishments from occurring. Let me hear from the other side of this counsel. Go ahead, sir.
Yes. Good morning, Your Honor. Just to reiterate everything that you just mentioned, the existence of the payment arrangement or the installment payment order does not prevent my client from filing a tax garnishment, which is what we have here. Her objection is invalid. And since the defendant did mention the previously entered installment order, we've received one payment in accordance with that order, and then two $25 payments and one $50 payment. At this point, we believe the defendant is $500 behind on her current installment payment order, regardless of its existence or not. So.
All right, and you have not moved to set that aside. I don't see any motion in that regard.
Oh,
sir.
Your Honor, the installment order was entered at the same hearing as the previous objection in June. So in the interest of judicial economy and time, I was wondering if I could file just an order setting that payment order aside, or if the court would prefer I do file the motion. The motion is prepped. I was just holding it pending the outcome of this hearing. So,
Right, yeah, in a roundabout way, you finally answered my question, that is that you have a valid motion to set it aside. I will wait for the motion in that regard. Unfortunately, it sounds like that may very well be a problem. I know Ms. Calhoun has indicated to the court that she's trying, but whatever the order is, that's what she has to be in compliance with. Ms. Calhoun, I don't see a basis on the objection as a related. The only thing I'm dealing with today is the objection regarding the Michigan Department of Treasury. Even if you're paying under the installment agreement, that does not prevent the plaintiff from pursuing collection by way of intercepts of the tax return or intercept as it relates to bank accounts and things of that nature. So I don't find that the objection in this matter is valid, and for that reason, I'm going to conclude that any funds that are withheld from the Department of Treasury, that those funds be released to the plaintiff to be applied towards satisfaction of the judgment. Now, as it relates to the issue of your partial payment agreement, they're saying that you are way behind on that, and they're likely going to file something to have that set aside. If that is set aside, then they can garnish your wages once that's set aside. They're asking that it be set aside. I'm not going to address it today, but that's the approach that they're going to take, because they believe that you're $500 behind your partial payment agreement.
Okay.
That is my word. I do wish both sides well. You receive a copy of my order in mail.
Okay, Judge, I'm sorry. That's not accurate. I did hear what he said. I don't know when he checked last with whom. That I just spoke with them on Monday, maybe, or Tuesday, and I made another payment as well. So that amount is not accurate, but I mean, okay, whatever is necessary. It's just stressful. Okay.
Ms. Calhoun, I'm not ruling on that issue. I'm just saying that that's what they're saying now. When they file some
Okay.
paperwork to try and set it aside, you can raise whatever issue you believe that something is inaccurate, and you want to make sure that you put that in writing so that those things can be reconciled. But I did want you to know that it's important. I know how difficult these times can be, but it's certainly important to stay with the payment agreement, because if you get behind on it, they can get it set aside. And if that's set aside, then they could garnish your wages. So that's the only reason I raised that today. But I'm not addressing that issue today. That could come up in the next couple of weeks or so. I wish you well. Thank you, Council. Good day.
thank you, Your Honor.
Okay. Okay.
is
Can
there-
I go in a breakout room? Because I'm not understanding a lot of what's going on, and I apologize. I just need somebody to break it down for me more. With you saying that's a separate issue, so I don't know where to go from here.
Mr. Memo, you got a moment?
Yes, Your Honor. Real quick though, before we do go into a breakout room, will the court sign an order, or would the court like plaintiff to submit an order?
I've already signed the order regarding the garnishment. That will be sent. That'll be sent out as mail.
Okay,
Thank
so
you,
what
Your
is? Okay,
Have a
so
great
what
day.
is that doing? You're signing to do what? What's going to happen from here?
Okay, what that is denying your objection, because you don't have a basis for the objection. So that means that any money that is being withheld by the Michigan Department of Treasury, that those funds will be turned over to the plaintiff to go towards paying the judgment that is outstanding. All right, now I'll give you a notification for a breakout room. Go ahead and click in and wish to you what I did to you.
Okay.
Thank you, Your Honor.
The court now calls case number 07144-097. This is Modern Financial versus the Eric Brown. The matter is before the court on the following objections to a writ of garnishment regarding Bank of America account. The record should reflect regarding this matter that judgment was entered initially in 2007 for $4,986.67. Subsequent to that time, the judgment was granted renewal. And that looks like it was in 2017. And there's an outstanding balance on the judgment. Your appearance for Modern Financial, please. For Modern Financial, let me see if I have Mr. Eric Brown on the Zoom, or Eric Brown. Who is that? Say something to me if you're on the Zoom.
Yes,
What's your
Miss
name?
Brown, Dietrich Brown.
Dietrich Brown. Okay, got it. Sorry about that. All right. So you got a judgment outstanding here. It says my bank account paid representative account someone else funds. What are you talking about?
I am a payee on someone else's bank account, and they debit someone else's account.
All right. So when you say you're a payee, what are you talking about there?
A payee representative of a special need person that's disabled.
All right. So where does that person receive funds from?
SSI.
Is that the only money that ever goes into that account?
Yes.
Did you speak to anybody today for Modern Financial?
Could you repeat that?
Yeah, did you speak with anyone from Modern Financial today?
No, I have not.
Okay, let me see. Just one moment. Okay, so I'm going to see if I can reach out to the other side, because obviously if there is a situation where the account is in fact someone else's account, okay, then they should not be able to garnish that account. Oftentimes those things have to be proven and established with a record history. So let me get back to you in just a moment. I'll recall you back shortly. Okay, the court now calls case number 1111-7844. This is independent ER physical versus Ashley Ward. The matter is before the court on the following objections to a writ of garnishment. This relates to L&L Gad Associates, I believe. It says I didn't announce this debt, and just finding out about it, or something along those lines. All right, this just one moment. All right, do I have counsel for independent ER physicians? Your appearance.
Good morning, Your Honor. Robert Goodman, P55670, appearing on behalf of the plaintiff.
All right, thank you, Mr. Goodman, and good morning to you. I'm looking now for Ashley Gordon. Say something to me now.
Good morning.
Good morning to you, Ms. Gordon. I see that the two of you had a chance to talk about this a bit in the breakout room. Anything you could update me on, Mr. Goodman?
Unfortunately, Judge, we were unable to resolve the matter. I think that she would like to proceed with her objections to Gar.
All right, now, I don't have all of the paperwork on this file. What is the amount of the outstanding judgment, sir? So,
Judge, this was a judgment that was entered on October 11th of 2011. And at that time, the balance was $908.19. And the current balance is $1,171.65.
So, Ms. Gordon, tell me what you want to tell me about this matter, ma'am.
I don't believe that this was me. At the time, well, when the initial garnishment was filed, I wasn't even here, or whenever this was defaulted, I was in Texas. I was explaining to him, if this was something that I did, I would have no problem paying for it. However, I don't go to Garden City. So I was asking if there was any type of records with my signature, something to show whatever services, but I don't recall ever going there. And this is the first time I'm ever hearing anything about it, because it came through my current employer, but I've always been employed. So that's why I'm like, I haven't gotten anything about this until I got a garnishment.
Yeah, well, you really, the law doesn't allow you to raise that kind of objection in a post-judgment hearing. What you're saying is that the judgment never should have been entered. You have to file a proclamation in order to get that before. This is post judgment. I can't even go back to those issues. Last you filed the proper paperwork indicating that you believe the judgment should be set aside or something. So you have to do some research and go back. This judgment has been in place for quite a significant period of time.
That's what I'm saying.
Yeah, the law does not allow you, court rules do not allow you to deal with the underlying case. You're dealing with the post judgment. This is collection stuff. If you want to attack the underlying case, you have to go and file some type of motion to try and get that set aside, to try and show that there's good cause to set it aside, that you have a meritorious offense to it. You have to follow that process. The only thing that I can address today is whether or not, in fact, there is a judgment in place, and there is. Because there is a judgment in place against you, the plaintiff has the right to collect on the judgment. And that's what the garnishment to LNL Associates is all about. Let me hear from counsel on this.
Yes, Judge. We filed a response to defendant's objections. I hope it made it to the court file. In there, we simply indicated that she's challenging the underlying judgment. Doesn't fall into one of the categories that you can object to a garnishment pursuant to MCR 3101 K1. We did talk out in the breakout room. This judgment was, like I said, it entered back in 2011. A review of the court file reveals that personal service was effectuated on the defendant.
It was not.
She acknowledges the address.
I let people talk. Excuse me a moment. I let people talk, and then when they get finished, somebody else has something to say. That's how we deal with it. All right, go ahead, sir.
So according to the court file, there was personal service effectuated on the defendant. There's been garnishments filed in 2011, 2012, and other dates as well. We finally we received a disclosure from the garnishee defendant that in fact she's working and that that money will be sent to us. And again, we don't believe it's too old, and she hasn't filed the appropriate motion nor provided any documentary support for her position.
All right, and now, Ms. Gordon, I know that you indicated previously that you did not receive any documents about this case back in 2011. You already told me that, but you have to raise that in a different setting. You can't raise that post judgment as part of the call. So, ma'am, how much money is being taken out of your wages to
$385.
Is that what do you get paid every other week or?
Yes, biweekly.
So bi-weekly, you're withholding 300, how much?
$385.
So I don't see a basis to set the garnishment aside. You might want to consider a partial payment time situation until you get until you decide on filing your motion or whatever. If for some reason this case is any money that's been taken from you would funded to you. But in the meantime, you got a judgment against you, so you gotta deal with that. So is there only one that you've been garnished? Have they taken money one time or more than one time?
One so far.
When is your next payday?
Next Friday.
All right, so tell me, ma'am, I don't see I don't see a basis for the objection of the garnishment. I know that the judgment amount is somewhat low to the ground, and not to suggest that it's not significant, but at least it's not a $5,000, $10,000 judgment. So the garnishment at $300 pay period, two garnishments, that's more than half of what the balance is. So how did you want to go? You wanted to you want to try to get a partial payment, or you want the garnishment satisfied? What do you want to do?
Oh, you're asking me?
Yes, ma'am.
I honestly don't know how to proceed with this, because I really don't. I don't know. This is my thing. If I'm responsible for something, I have no problem paying for it. But I wholeheartedly do not believe this was me. because I don't even live in Garden City.
I believe that you told me that about 3 or 4 times. I don't know why you think that you should tell me that again.
Oh, I don't, because I was
Really?
saying, I don't know what to do from there.
The big ears hear it the first time around. But
Okay.
I really the issue that I'm raising with you is how you want to go out payment. But you can always file a motion for partial payments. Right now, I'm just leaving the garnishment in place. If you at some
Okay.
point desire to file a motion for partial payments to pay less than what the garnish amount would be, then you can feel free to file that motion. I'll consider it as to a lesser amount while you consider what you want to do in terms of time on the line. You have the right to file a motion to try to get that judgment set aside. Until you do that, then the judgment is still in place, right? All right, so that's my determination. I do wish both sides well. I'm signing the order now. Finding that the objections are valid, the funds held will be released to the plan.
And then you said I have to file I can file a motion for partial payment?
Yes, ma'am, you can do that to lessen the amount, try to lessen the amount that you should pay, right? All right. Wish you well.
Thank you, Your Honor. We appreciate the court's time and have a great holiday.
And I'll let you as well, sir.
Ms. Poe, place your device on mute.
Ms. Cole, you're back. I was already finished with your matter. Is that correct, Ms. Cole?
I'm sorry. Can you start
They
it
were in
again?
the breakout room, Judge. They're back from the breakout room.
All right, yeah, but did I already resolve the matter? Okay, who's on the other side of Ms. Cole's case?
I think it was Michael. Progressive.
I apologize, Your Honor. I was trying to unmute. I got a late notice. Apparently, I have a 10:30 that we did not get notice of with another court. But I am on the other side of Progressive versus Poe.
Okay, yeah, that's 16-100, 661. Back on the record, in Progressive Michigan Insurance versus Tayana Poll. The matters before the court on the filing objections to a writ of garnishment regarding a bank account. Your appearance for Progressive.
Yes, Your Honor. I'm sorry, I couldn't hear the last part, but I think you were asking what's going on with the case. So we have come to a resolution. Just to give the court a little bit of procedural history, Ms. Poe filed this objection to our tax garnishment. The reason for the objection was that she was going to file a motion for installment payment plans. I think that's been filed, but it has not been heard. So at that point, there was no installment payment plan in place. We discussed that obviously we would argue to the court that even if installment payment plan was in place, that would be an invalid objection because a non-periodic garnishment is not stopped by installment payment plan. But while we were in the breakout room, we agreed to a payment plan. So Ms. Poe is going to pay $150 each month starting the last Friday in December until the entire amount is paid in full. This will prevent the wage garnishment that we anticipate is coming down the line. She received notice, but so they'll stop that. And then it will also help to reinstate her driver's license, which has been suspended as well. As I told Ms. Poe, this will not stop though the tax garnishment, which is kind of the subject of our appearance today.
All right, Ms. Cole. So, Ms. Cole, I think you got a lot of noise in your background or somebody.
So, and I don't know if she can hear you. She's at work too. So,
Okay, got it. All right, Ms. Cole, you hear me okay now? Ms. Cole, you hear me?
Hello?
Yeah, Ms. Cole, are you able to hear me? Ms. Paul?
Why is it on my phone doing this?
Oh, look like she's gone. All right, so on representation of the council, I will sign an order for partial payments at $150 a month commencing on the 30th of December 2022. On
Thank
review of objections filed in this matter, I note that the objection that was filed says I have filed a motion for installment payment. So that was the expressed interest of Ms. Poe. That would not be the basis for stopping the type of garnishment that is directed to the Michigan Department of Treasury. So I find the objections are valid there. Any funds withheld will be released to the claimant. But then, Ms. Poe, I am allowing the $150 a month payment towards the judgment beginning in December 2022, December 30th, and each month, the last Friday of each month until the judgment is paid off. That would prevent wage garnishment. That's what you wanted to do. Is that correct?
Yes.
All right, anything else you wanted to tell me at this time, Ms. Paul?
No.
Well, that sounds like no and yes.
It is a no and a yes, but I'm kind of happy about the part about getting my license back because I've been really driving on eggshells at work.
You're not supposed to be driving on nothing, eggshells or anything. But
I know, but I have to work to pay.
okay, don't be admitting to no crimes here on this record. Looks like Ms. Williams is going to work with you in terms of being able to use this payment agreement to get your the suspension. Really, that's the best thing that could come out of this. Okay, so
Yes.
get it, do whatever has to be done to go ahead and get that taken care of. Okay? I do wish you well, man. Thank you for hanging in there. I know these are tough times. You know? Yeah, that driver's license is going to be really important. So,
Yes.
thank you, Ms. Williams. For,
Thank you, Your Honor. Have a happy Thanksgiving. Thank you, Ms. Poe.
You guys have a good Thanksgiving.
likewise, you, man. Good day.
She said that okay.
Okay, Ms. Brown?
Yes.
Okay, so the attorney on the other side is not available today. I think that you have a good case for getting that garnishment lifted. I want to hear from them to figure out what's going on here. So I'm going to have you come back, and I'm going to give you a new date to come back and see you, so we can try to work through this. So I'm going to go ahead and set this up for December 1st, Thursday, December the 1st. So the information that you have, ma'am, just come back into the Zoom that day, and this case will be set up for hearing that day. And the other side should be here at that time. If they're not here, then I'll set aside the garnishment immediately.
Okay, thank you. Thank you, Your Honor.
That's December the 1st at 9:30 a.m.
Okay. You have a blessed day.
All right, likewise, happy holidays.
Same to you. Bye-bye. I'm off.
Yeah.
Your Honor,
Yeah, who's talking to me?
I'm off.
Yeah, you're all set.
Okay.
December 1st, I'll see you again, okay? All the best.
Same time?
9:30, same time, same day, please. All right.
All right. Have a good day.
All right, thank you. Thank you for your patience, everybody. This is case number 22-18781. This is Southeast of Michigan LLC versus Regina White. The matter is before the court on the following objections to a writ of garnishment. This is related to a judgment that was entered on the 30th of August of 2022 for $3,166.30. This is a garnishment regarding the Detroit Medical Center. Appendix objection says I didn't understand or didn't understand or me owing money and
Hello?
zero time. I don't know what that is. All right, so let's get to it. For Southeast Michigan LLC.
Good morning, Your Honor. For the record, Tom Hocking at behalf of plaintiff P30955.
Thank you, Mr. Hawking, and good morning to you, sir. I'm looking for Miss Regina White at this time. Say something, ma'am, if you hear.
Hello, you hear me?
Yeah, I hear you.
You
Good
hear-
morning to you.
Do you hear me? Good morning. How are you?
Morning. I'm trying to help you get back to your turkey, but, take it.
Yeah, yeah.
You got a judgment against you, and that's why they're attempting to garnish your wages there. You work for Detroit Medical Center?
Yes, I do.
Okay, so you're saying that you didn't understand something. Tell me which one.
Well, when I had received, someone had come out to my home and I had received a paper over the summer. And so I didn't know what was going on with the paper. So I had wrote to the court and I thought I was waiting on a court date. So I didn't receive a court date. And so I didn't know what else was going on. And so when I called and spoken with them, I couldn't get an understanding on because I thought that everything was okay and the rent and they kept the deposit was done. So then I received the garnishment at work. So that's when I went down to the court to ask them about it. And so this is when they gave me this date to talk to someone. And I was telling them that I didn't understand, could I get someone to help represent me? But I didn't know what else to do. But then I was looking on this paper where it was telling me to call this number and see about it. So I was trying to go from there to see what else I need to do first, if the situation to stop the garnishment or make payments or however I need to do it to make sure what was going on.
Yeah, what happened, ma'am, is as a starting place, you didn't file an answer or responsive document to the complaint with the court, and therefore the judgment was entered by what's called default. You didn't respond, so it was entered by default. And once that judgment is entered, then after a certain number of days expired, the plaintiff or the party that holds the judgment has the right to come after you to try to get payment on that judgment. They could garnish bank accounts, wages, seize property, etc. In this instance, they've gone after a wage garnishment. So has any money been taken from your pay as of yet, ma'am?
No, it hasn't been taken. Anything has been taken.
Do you know how much do you usually take home? You get paid every other week or every week?
I get paid every other week.
All right, how much do you usually take home?
$1,000.
Okay, so they would take $250 from you each period, so about $500 a month is what your garnishment would be. I don't think that you stated a valid reason for objecting to the garnishment, but I did hear you tell me that you're looking for a way to make some type of partial payment agreement to try to get this resolved. Let me hear from Mr. Hopkins, and I'll come back to you.
Well, I was saying that,
One moment, ma'am. One moment. I'll come back to you, Mr. Hopkins.
Well, if she wants to pay a reasonable amount, I think that would be fair.
All right, so Miss White, what would you like to pay per month to try to get this resolved?
well, per month will be $150 or how would I do that? Will I pay that to the court or to the station?
Well, we'll get that second part taken care of in a moment. Mr. Hocking, the amount has been suggested. Any thoughts, sir?
Well, Your Honor,
One second, Ms. White. Mr. Hocking.
Your Honor, if the amount is $250 that is getting on the garnishment, I'd like to see $200 a month. I think would be reasonable.
Well, actually, the overall amount would be $500 on the garnishment, $250 each pay period.
Right. I think that at least $250 a month would be appropriate. The one payment, split it in half.
That's a little high, ma'am. You want $150, Mr. Hocking wants $200 a month. Tell me where you are. Can you do $200?
Okay, I would be able to try to pay the $200, but I also want to ask Mr. Hawkins, was there reasonable of anything of a lower amount? Because I was understanding that the rent was paid up to a certain amount and deposit was kept from the
Right.
rental.
Yeah, if you're gonna raise those issues, then you have to file a different type of motion to try to get the judgment set aside. Those issues are not before me today. Whatever the judgment is at this point, that is what it is. If you believe that that judgment should not be that amount, or that it should not be entered, you could file a motion on the second floor of 36th District Court, and do it online as well, asking the court to consider the amount based upon what you believe is an improper calculation to raise those issues. Here today, the only issue that we're raising is the issue of the judgment enforcement. They're attempting to force the judgment against you and collect from your wages. And you're telling me that you would like to be able to pay it voluntarily without them taking automatic $250 per pay period. That's what you're telling me, correct?
Okay, yes.
Okay. All right, so let's so I'll split the difference. I'll set the installment payment at $175 a month. When do you want to make your first payment, Ms. White?
What's today? Well, December December the
Well, you could do the 23rd or the 30th. Well, give you a little latitude.
December the 30th.
Whether you want to take it to the end of the year?
December the
Okay.
30th.
Yes, ma'am. So you're gonna pay $175 a month, commencing on December the 30th, 2022, and continuing each month thereafter until the judgment has been satisfied. Under that scenario, I will suspend the garnishment. But obviously, if for some reason you don't make the payment, then the garnishment comes right back in place, and then you'll have a hard time trying to get it set aside. You understand?
Yes. Well, I'll be able to make the payment. And I'll be able to take care of the payment and everything. I was just trying to make sure everything was right. So you said I have to go back down to the second floor, right?
That's if you want to file a motion regarding trying to get the judgment changed. You would have to file some type of motion, some type of document to try to get the judgment changed. Right now.
And when you say judgment change, what that mean?
Well, you're trying to get legal advice, and unfortunately, the law doesn't allow me to do that. I can only tell you that if you believe that the judgment is wrong, you can file something saying, I believe this judgment is wrong. It's wrong for these reasons. It should not have been entered for these reasons, so on and so forth. If you file that, then the court has to take a look at it and consider and think about what may have happened. Doesn't mean that you win it, but the court has to take a look at it and consider it. So if you want to do that, you still have the right to do that, even though you have a payment plan and everything. You still have the right to file anything that you want to file to attack the judgment if you wish to.
Okay. Okay, thank you.
Mr. Hockey, you got a moment to speak with Ms. White just regarding payment logistics, sir?
Certainly, Your Honor. I just would say, though, that she just makes the payment out to plaintiff and sends it to my office, and I'll send her the documents that support the claim. If she has any questions, she can contact me then.
Okay, you got that, Ms. White?
Okay, yes, please.
Okay. Okay, so you don't have to go to the breakout room. That information should be sufficient. You'll get the partial payment order, and you'll get the order on the objections, finding the objections invalid. If there was any money withheld, I would release it to the plaintiff, and then it will be suspended pending your payments under the installment bill. All right. I wish you well, ma'am. Thank you.
All right. All right. Thank you. Have a blessed holiday.
Thank you, Your Honor, and to your staff and you, happy holidays. Thank you for your help.
You say I have to go to the breakout room?
No, you don't. You're all set to go, man. You can leave now.
Okay, so what, I will receive the papers, or what will I do?
Yes, you gotta receive papers in the mail from me, okay? The court's gonna send you some papers out.
Okay then, thank you.
Thank you, Your Honor.
I can hang up?
Hang up now, man. I'm sorry.
Oh, no. You can.
We'll put it up. Somewhere.
Okay.
Okay, the court now calls case number 07101-461. This is Asset Acceptance LLC versus Georgetta Michael. The matter is before the court following objections for writ of garnishment. Excuse me. This is regarding the Charles H. Wright Museum. It looks like a wage garnishment situation. The judgment was entered in this matter. Looks like on the 10th of May, 2007. Total amount was $1,429.62. All right, your appearance for asset acceptance, please.
Good morning, Your Honor. J Baig, BAIG, P36820, appearing on behalf of plaintiff and the attorney of record. And this is asset acceptance versus Michael.
Yes.
Nope. Okay.
Good morning. Thank you. Thank you very much, sir. And I'm looking now for, I guess the last name is Michael. If you're on the Zoom, please say something. Oh, yeah. There you go. Good morning to you.
Good morning, Your Honor.
All right. I see that you filed objection. You were pointing out that you have an installment order that was issued on May 10th of 2007.
Your Honor, may I interject? We've settled this.
All right, go ahead, talk to me.
Okay. We settled this for a lump sum of $2,110. And what I would like to do is adjourn this objection hearing. If we could do, adjourn it maybe 30, 45 days so that it'll give time for Ms. Michael to send the payment and for the council to send a satisfaction of judgment.
Ms. Michael, that makes sense to you, man?
Yes, sir.
So how much time do you think that you need to do the part that you have? Because that will determine how far I'll adjourn.
Well, sir, as soon as I'm done with the court, I'm going to the bank and take out all my money, Christmas and everything, and I'm going to pay this because I don't need this sword of Damocles hanging over my head, sir. And I apologize that I let this happen, but I was told that it was a credit card in 2007. If they had told me that it was 1996, I would have said, okay, no problem. I know what you're talking about.
All right, yeah, I got you. So it just mushroomed over time. So what I will do then is I'll adjourn it for 30 days. So the parties can work out what they need to work out. So the next date on this thing, I'll take a look at. Let's do the 22nd, December 12/22, 22, and 9:45 p.m. I'll set the matter for review at that time.
This means I have to come back to court?
Now, if you get it all resolved, you don't have to come back. That's a control date. Okay. That date is if something falls apart, it gives the parties the opportunity to come back and say, Judge, this is what happened. And, Judge, we need to make a decision. But if you get it all worked out, then Mr. Bay's office, his client is going to send in a satisfaction judgment. That's in this case. Okay.
Judge, so that date was December 22nd, 9:45
AM.
a.m.
All right, good day to the two of you.
Thank you.
Thank you. Happy holidays, Judge.
Yes, ma'am, indeed. Okay, do I have All right, now what case are you here on, council? I don't have.
Trust Property Management versus Charmaine Elvis. It was adjourned until today, but Your Honor, we're gonna file an order of dismissal on this. We've reached a settlement. So if it's not on the court's docket, we'll have something submitted to the court.
Yeah, that's perfect. Let me see what happens. 1 second.
Too much interference.
Yeah, I do see it. It's 22-195-463 Trust Property Management versus Charmaine Alvis. Unfortunately, I didn't have the file in front of me. Something went wrong here. Your appearance at the for the record, counsel.
Hobbs and Silva on behalf of plaintiff.
And your P number, just go.
Oh, sorry, PA2080.
All right, I have Ms. Charmaine Alvis on the Zoom. Good morning to you, ma'am. Say something here.
Good morning, Your Honor.
So you have, ma'am, the attorney tells me that the parties have come together and you resolve this matter, and paperwork to be sent in, dismissing the case. Correct?
That's correct, Your Honor. I don't know if the court wants to hear the terms, but it's been settled via email between me and Ms. Elvis. We've reduced the amount that's due by a substantial amount. She agreed to it. I'll submit a copy of the order to Ms. Elvis for signature, and I will send it to the court.
All right. So you reached an agreement, Ms. Elvis, is that correct?
That's correct. I just wanted to make sure that that the amount that we came to agree upon is the final amount, and that we're done. That amount resolves the case.
That's the final result of the case.
Okay, great.
That's there's no switching up. Whatever that agreement is, that resolves the case. To do something, that's something.
She'll get a copy of the order to sign it, so she won't be able to sign it.
So, yeah, you'll get paperwork resolving it. All right. All right. I wish you well. Good day to you.
Thank you.
Thank you. Happy holidays.
Oh, I don't know what that noise is. What'd you say, Judge?
What did I do on independent ER physician versus Ashley Ford?
What did you do? That's a good question. I just have independent room. I don't know, but you called it. If you give me a minute, I have to look it up.
Sorry.
Did you hear me?
Yeah.
Yeah, I don't have nothing here. For them. But I know you did so.
Okay, yeah, this is the whole case. It's just a matter of filling out the top stuff.
Okay.
Partial paperwork.
And you are you able to for that back? Oh, okay.
Oh, you're talking about the one I
The
just had.
Alvin, yeah.
Yeah, they're gonna send it in.
Oh, they're gonna send me. Okay.
So, your record should be the cases, so.
Okay. When
Do you remember what happened on, man, I gotta look at this independent ER physician versus Ashley Ford.
I don't.
Wait a minute, yeah. This is your.
Okay.
She said, I told her she could file for partial payments at some point. She wants it. That's what I said. So you didn't upstairs. Everything's going on. I'll be back.
Okay. All right. Thank you.
Hold on, Judge. I got it.
Right there. Go, yeah.
You going to another courtroom?
Yeah, I gotta go to the fifth floor, you're not doing that
Oh,
because of, I think Judge Giles.
oh. I was.
All right, so I'm gonna step out of this,
Okay.
do it as fast as we can.
I couldn't look on the thing. Oh, yeah, that was just, I remember this. It's too loud. You kept it. Where's the sound?
And at that time, the balance was 908.19. And the current balance.
I can hear you, Deb.
Oh, sorry.
Want to try the partial payment?
Did he find out what he wanted to know?
Satisfied, 21.
I'm sorry if I'm loud.
I believe he did. Yes, he did.
You're asking
Oh,
me?
okay.
Yes, ma'am.
All right then. Well, I'll see you later, young lady.
I'll proceed with this because I
Yeah,
really
have a good day today.
You too. Tell your mother I said hello.
Okay, I will.
Okay.